Good afternoon, everyone. Welcome to the Committee on Commerce and Labor, the Assembly Committee on Commerce and Labor. Madam Secretary, please call the roll.
Assemblywoman Carlton.
Here.
Assemblywoman Considine.
Present.
Assemblywoman Dickman.
Here.
Assemblywoman Duran.
Here.
Assemblyman Flores.
Present.
Assemblyman Frierson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman Kasama.
Here.
Assemblywoman Martinez.
Present.
Assemblywoman Marzola.
Here.
Assemblyman O'Neill.
Here.
Assemblywoman Tolles.
Here.
Chair Howdigi.
Here. Madam Secretary, please note that all members are present and we have a quorum. Welcome to our audience tuning in over the internet. Before we get started, I'd like to go over some housekeeping. Please remember all exhibits, written testimony, and amendments are required to be turned in to the committee secretary by noon the day before the committee meeting. Persons who wish to provide testimony must register online at www.leg.state.nv.us. Persons who wish to provide, the public is strongly encouraged to submit written testimony in advance of the meeting by emailing asmcl.asm.state.nv.us. I will remind everyone that the Zoom chat is strictly reserved for business only. Members, please remember to keep your camera on at all times. This will help ensure that we have a quorum. Members and presenters, please remember to be muted at all times. Unmute yourself prior to speaking and then immediately mute yourself when you are done. Thank you to everyone for being here, and let's get started with our agenda. We have 3 items on our agenda today, 3 bill hearings, and we will be taking them out of order. We will be starting with Assembly Bill 73, and I believe we have Ms. Leticia Metherell with the Division of Public and Behavioral Health here to present the bill. I will now open the hearing on Assembly Bill 73.
Madam Chair, members of the committee, for the record, my name is Leticia Metherell from the Division of Public and Behavioral Health. Thank you for this opportunity to testify before the committee. The Division of Public and Behavioral Health is responsible for the licensing and regulation of the practice of dietetics in Nevada in accordance with NRS and NAC Chapter 640E. As of February 3rd, 2021, there are 721 licensed dietitians and 7 provisionally licensed dietitians in Nevada. The division decided to move forward AB 73 along with a proposed amendment because effective January 1st, 2024, the Commission on Dietetic Registration, which I will refer to as the CDR from now on, will be changing the minimum degree requirement for eligibility to take the registration examination for dietitians, which is currently a bachelor's degree, to a graduate degree in 2024, and all the other eligibility requirements will remain the same. This bill and the accompanying amendment is intended to clean up discrepancies in statutes and make other changes to reflect updates in the name of the organizations, eliminate some unnecessary fees, revise provisional licensing requirements, remove a provision that would penalize registered dietitians who were previously licensed in Nevada and want to return to practice here, and repeal sections of NRS that are no longer needed. The CDR will be grandfathering in currently registered dietitians with a bachelor's degree, so they will be able to continue to work as registered dietitians, and if already licensed in Nevada, be able to continue to work as licensed dietitians in Nevada, as long as they do not let their registered dietitian status expire. If an individual allows their registered dietitian status to expire, they would have to meet the graduate degree requirement in order to become a registered dietitian. In addition, the individual would not be able to renew their dietitian license until they met their graduate degree requirement in order to become a registered dietitian again. An article from the Journal of the Academy of Nutrition and Dietetics noted that elevating the entry-level educational level of registered dietitians is consistent with the knowledge and skills required in this field to protect the public, remain competitive, and increase recognition and respect. It also noted that graduate degree requirements do not deter students that are interested in the health professional career. The nutrition programs at the universities of Reno and Las Vegas were also consulted, and they felt that the universities could meet the graduate level demands as a result of this change. In addition, a member of the Nevada Academy of Nutrition and Dietetics noted that they were in support of graduate level degree requirements and the provisions in the proposed amendment that would require an applicant to meet the eligibility requirements for an individual to take the registration exam that has not yet passed the exam. Section 1 of the bill amends NRS 640E.150, which currently requires a bachelor's degree, and it also requires successful completion of the registration examination. This means effective January 1st, 2024, the statutes would end up requiring 2 different degrees if this bill was not passed: a bachelor's degree in one section of the NRS and a graduate degree in the other section of the NRS, since the applicant who has not already taken the registration exam would be required to have a graduate degree in order to take the exam. Section 1 replaces the current initial dietitian licensure qualification criteria with the criteria that an individual must be a registered dietitian in good standing to make it clear what the requirement is to be a licensed dietitian. It also keeps Nevada statutes current anytime the CDR changes the qualifications for an individual to become a registered dietitian. The CDR is the nationally recognized expert when it comes to administering credentialing standards for registered dietitians to protect the public. Section 2 revises NRS 640.170 to no longer refer to the education and experience required by NRS 640.150, but instead allow a person eligible to take the registration exam but has not successfully completed exam to engage in the practice of dietetics under the direct supervision of a licensed dietitian. An amendment is being presented to change Section 3 NRS 640E.180 so that an applicant for a provisional license must meet the eligibility requirements to take the registration exam, including the minimum college or university degree requirements, a didactic program in dietetics, and completing of the dietetic internship as per required by the CDR, but in which the individual has not successfully completed the exam. This ensures that an individual would be qualified and have the time to take the registration exam before the provisional license expires in order to be able to apply to become a licensed dietitian. Once that degree requirement changes from a bachelor's to a graduate degree. Section 4 amends NR 640E.220 by repealing the requirement that the board shall require a licensed dietitian who fails to submit an application for renewal of their license within 2 years after the date of the expiration of the license to take the examination, the registration examination currently required in NR 640.150. The current statute penalizes registered dietitians who are licensed in Nevada but left the state to practice as a registered dietitian in another state and who want to return to practice in Nevada after 2 years. But at the same time, it would allow a registered dietitian who was never licensed as a dietitian in Nevada to apply for licensure without retaking the registration exam. As the bill requires an individual to be a registered dietitian in order to become licensed in Nevada, the fact that an individual is a registered dietitian should be enough to allow them to apply for licensure without having to retake the exam. Section 5 eliminates 3 unnecessary fees, with AB 73 requiring an applicant for initial dietitian licensure to be a registered dietitian in good standing. The examination of the applicant for a license would no longer be required. The late renewal of a license fee is not required because there's really no grace period, which allows for a late renewal license. So an individual that allows their license to expire submits a new initial application. This does end up penalizing a licensed dietitian by requiring they submit a new initial application, which results in additional costs and inconvenience of getting another background check done. The division's online licensing system allows dietitians to log into their account and print a duplicate fee. Therefore, the fee for issuing a duplicate license is not needed. The fee for processing a change of name application is still needed, so the amendment does request that remain in place. Section 6 of the bill removes the requirement in existing law that a licensed dietitian who fails to submit an application for the renewal of the license within 2 years after the date of the expiration must take the registration examination. I already explained that one. Section 7 repeals NRS 439.537 for NRS 640E.160 and NRS 640E.210. NRS 439.537, the unlawful use of words or letters designating person as a licensed or registered dietitian is being repealed. As NRS 640E.360 currently has language that would prohibit an individual to represent themselves as a licensed dietitian or qualified to engage in the practice of dietetics. So it's pretty well covered in current statutes and the same chapter where everybody can find it. NRS 640E.160 is being repealed as a foreign education equivalency will be addressed in the process required for an individual to become a registered dietitian. Repeal of NRS 640E.210 would remove the ability for the board to waive requirements to become a licensed dietitian, including the requirement to take the registration exam. This provision has never been used to waive licensure requirements since the first dietitian license was issued in 2013. In addition, this would no longer be needed with passage of AB 73, as all initial applicants would be required to be a registered dietitian in order to become a licensed dietitian. So it would eliminate all those individual qualifications in the statutes, as that would be covered as part of the registered dietitian process. The proposed amendment revises NRS 640E.080, .090 and .290 in order to update the name of the Commission on Dietetic Registration and the name of the Accreditation Council for Education and Nutrition Dietetics. So it's just cleaning up some names. It also amends 640E.180. So an applicant for a provisional license must meet the 3 eligibility requirements to take the registration exam, and keeps the ability to assess the fee for the change of name. In summary, the purpose of the bill and the proposed amendment is really just to clean up the statutes to remove any discrepancies when a graduate degree becomes a requirement to take the registration exam in order to become a registered dietitian instead of the bachelor's degree, making the requirements for licensures clear, providing time for the provisional licensees to meet the requirements to become a licensed dietitian, not penalizing registered dietitians who becomes licensed in Nevada and wanted to return, and removing unnecessary fees. This concludes my testimony. May I answer any questions?
Thank you so much for the presentation, Ms. Metherell. We do have some questions for you. Committee members, if you have questions, please use the chat feature to let me know. I will get our questions started with Vice Chair Carlton.
Thank you very much, Madam Chair. And I remember when we first did registered dietitians. So I guess and I understand what you're trying to do. It's always good to recognize a national organization and bring things up to standard. I always have concerns when we raise the qualifications to go to an undergraduate, especially if there's no grace period. So you're saying that if I had this license and I missed it by a day and didn't renew my license, I would have to go back and get my undergrad, even if I had been working in the state for 20 years. If I didn't get my licensure in and missed it by just one day, I would have to go back and get my graduate degree in order to continue my career in the state.
Yes, I'd like to clarify that the effect would basically be the same, but it would be if you missed your registered dietitian. because the bill would require you to be a registered dietitian. So you are correct. If they lost a registered dietitian and let it lapse by a day, 2 days, the CDR would require them to become a registered dietitian to obtain their graduate degree, which then in effect would mean that they would not be able to renew their license. So yes, the end
Okay.
effect is correct.
I think that's an issue. Computers go down, people make mistakes. I get penalized if I renew late on something, but if someone renews late and has to go back, and the difference between a bachelor and a graduate is kind of an expensive fine for possibly missing your renewal date. I think there needs to be some type of grace period. We have grace periods in other ways. So I would have some concerns about that. It's people could end up losing their jobs. So we just have some concerns about that. Thank you, Madam Chair.
Thank you, Vice Chair. And that actually, I'm glad you brought that question up. I had read it differently, and so that I have the same concern. So, Ms. Metherell, I'm just going to jump in and ask a question because it's in the same area that Vice Chair Carlton asked. So dietitians have to renew their registration and renew their license?
That's correct.
And how often? And the registration is renewed with the national CDR, and then the license is renewed here in the state, correct?
That's correct.
Then how often do they have to renew their annual, or how often do they have to renew their registration? Is that annual or?
I have Dr. Kruskal on the phone from the University of Las Vegas. I just want to see if she's available. I think it's every 2 years, but I'd like to confirm with her.
And if you're available, that would be great. If you could confirm how often the registration has to be renewed, and if the CDR offers a grace period for the registration.
Yeah, the grace period, there's no grace period that I am aware of. The 2 years, I think it's 2 years, but I'd like to confirm that and get that back to you to be positive. I want to make sure you have correct information.
Thank you. And then Ms. Metherell, I have the same questions for the license. So how often is the license renewed?
The license is every 2 years.
So they're both every 2 years, and then the license has no grace period either.
The license currently in statutes has no grace period. It was never put in the original statutes.
Okay, thank you. I'm going to take the next question from Assemblywoman Tolles.
Yes, thank you, Chair. And I also shared those same concerns and questions, so I will look forward to that follow-up. I was curious about the repealed section 439.537, taking out unlawful use of words or letters designating person as licensed or registered dietitian. And I believe when you were referencing 640E.160, that section, you said that that section was found elsewhere. I'm just wondering where it's covered elsewhere, that if I were, somebody who was not a licensed and registered dietitian, but I was promoting myself by fraudulently misusing those initials and those titles, where would I find that restriction and that penalty in statute?
That is, if you go to NRS, let's see, I have it here. NRS. It's in the chapter 640E.
It's okay if you need to get back to us. And just share that. I just wanted to make sure that we're not losing that restriction, so that we have some way of restricting people from fraudulently presenting themselves as licensed when they're not.
Yeah, it's in NRS 640E.
Want to confirm that later and get back to them?
Yeah, it's in there.
I am going to, if I can, call on our legal counsel. I believe he might know where that is in our statute. Mr. Costa, available? Apple.
Thank you, Madam Chair. Sam Quast, Committee Counsel. Yes, that is in 64E360, and it prohibits a person from using, in connection with his or her name, the words LD, licensed dietitian, or other letters indicating that they're a dietitian.
Thank you, Mr. Quast. And I would like to remind presenters that if you would please just introduce yourself before speaking, it will help our committee secretary. Assemblymember Tolles, did that answer your question, or do you have a follow-up?
Yes, thank you, Chair.
Okay, perfect. Thank you. Our next question is from Assemblymember Dickman.
Thank you so much, Madam Chair. I was just wondering if you could help me understand why we are taking this from a bachelor's degree to a graduate degree. What's the reason using that?
Yes, for the record, this is Letitia Metherell. Yes, right now, the CDR is going to be changing it from a bachelor's degree to a graduate degree. And they did a number of research. I have the journal article I'm happy to give to the committee, where they felt that that was the minimum requirements in modern age to have these individuals at the entry level have the skills they need in order to protect the public and consumers. And so that's the reason why. Also of note, if this bill does not pass, the master's degree would still be required, because the bill, the current statutes, if you look at the statutes regarding the criteria for qualifications, it actually requires that an individual pass the registration exam. And so when the graduate degree becomes effective in January of 2024, in order to take the exam, they'll have to have the graduate degree. So if the bill does not pass, they'll still need the graduate degree.
Assemblymember Dickman?
I was just wondering if you could tell us approximately how much longer that would take in terms of the education to qualify.
They would require the master's degree, and I would assume most master's degree take 2 to 3 years. So I would say an additional 2 to 3 years, since all of the other requirements are remaining the same, that it would be another 2 or 3 years until they, somebody was able to obtain the master's degree at a minimum.
Thank you.
Thank you, Assemblymember. And Ms. Metherell, I just want to clarify. So we're not changing the requirements, the education requirements. The CDR is changing the requirements, correct? That's a national organization?
That's correct.
Okay, perfect. And then I just need to clarify this again, just for the record. So we don't register dietitians. We just license dietitians. But in order to get a license in the state, you have to be a registered dietitian. Dietitians become registered with the national organization, the CDR. And you mentioned that the CDR does not have a grace period on renewals. So they would not be able to renew their license with us if they indeed were late on their registration renewal. Correct? And then if they were late on their registration renewal, then the CDR would not allow them to register until they then provided a master's degree?
That's correct. If according to the information I have, and I believe the Nevada Dietetic Association may be testifying in the public, so they would also have some information. But yes, my understanding is that if you're a registered dietitian and you let your registered dietitian lapse, the CDR will require you to then get a graduate degree in order to become a registered dietitian again.
Okay, thank you. Members, does anyone else have any questions? Okay, seeing Seeing none, I am going to go ahead and hear testimony in support of Assembly Bill 73. I believe I have someone signed up to testify in support on video. Dylan Martin with the Nevada Academy of Nutrition and Dietetics. Do I have Dylan Martin on? Okay. Broadcasting, can we check the phone line to see if we have anyone waiting on the phone to testify in support of Assembly Bill 73?
Yes, Chair. To testify in support of Assembly Bill 73, please press *9 now to take your place in the queue. Caller with the last 3 digits 000. Please slowly state and spell your name for the record. You will have 2 minutes.
Hello.
And may begin now.
Madam Chairwoman, this is Dylan Martin with the Nevada Academy of Nutrition and Dietetics. Can you hear me?
Yes, we can.
Okay, great. Thank you. I did not get the video link, so I was only on the audio only link. So thank you. I appreciate your time and appreciate the members of the committee. Like I said, my name is Dylan Martin. I'm currently serving as president of the Nevada Academy of Nutrition and Dietetics. Our organization is comprised of 447 members that includes registered dietitians who are licensed in the state of Nevada, as well as dietetic technicians, dietetic interns, and nutrition science students enrolled in Nevada's system of higher education. I'm speaking to you today to go on record in thanking the Nevada Board of Health for utilizing one of their BDRs to improve our licensure. I also want to mention that Dr. Laura Kruskal, who I believe is on the line as an expert, has been instrumental in helping to communicate with the Nevada Board of Health, and we owe her our thanks. At this point in time, the Nevada Academy of Nutrition and Dietetics has been reading the language in AB 73, and we do support the intended purpose of AB 73. I don't want to waste the committee's time with recapping all of the points of the bill, because I think Ms. Metherall did a good job of that, but it's our understanding that the original language submitted in the first draft of AB 73 needed some amendments, and we appreciate Ms. Metherall's time in presenting those amendments today, and we very much look forward to seeing the final version of AB 73. In addition, our organization will support the Board of Health and the Assembly Committee on Commerce and Labor to ensure that the language of AB 73 meets the needs of nutrition professionals practicing in our state. I'll also just quickly add, if I have time, because of the discussion, there were some questions that we renew our registration with CDR every 5 years. I am not sure either if there is a grace period with CDR. There may be a 60-day grace period with CDR to get that completed. So thank you, and there may be someone else on the call that can clarify what I just said.
Thank you, Mr. Martin. We appreciate your testimony. Broadcasting, is there anyone else on the line?
Yes, Chair. Will the caller with the last 3 digits 570, please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Hello, can you hear me?
Yes, we can.
Thank you. My name is Laura Kruskal, and I apologize. I'm sitting in a Zoom waiting room, and nobody let me in, so I apologize. I had to be available by phone. I was Ms. Meseral's expert witness. I'm the Director of Nutrition at the University of Nevada, Las Vegas. I've been there since 1999 and was responsible for developing all of our nutrition programs at UNLV. So just to clarify 2 points. Number one, the point about the whole master's degree requirement, yes, the the CDR is changing that requirement, but going back to our original provision or the original eligibility requirement for getting a license is you have to just be an RDN. So if somebody is an RDN and they let their so-called, if they let their RDN expire just because of a fee and they're reinstated, they would not have to go back and get a master's degree because they are an RDN in good standing with CDR. And Mr. Martin is correct. There is a grace period, and there's two processes of becoming an RDN. There's a 5-year, you have to renew every 5 years with continuing education. So that's one process, but then there is an annual fee just to maintain that credential as well, and there is a grace period if you miss that annual fee. So yes, there are grace periods as far as your credential goes. So it's very difficult to lose that credential.
Okay, perfect. Thank you. We appreciate you being on here to offer your testimony and support. If you would, please, would you spell your name for our committee secretary? And we apologize for not seeing you in the waiting room. It's a virtual setting and we're all still getting used to it. So thank you for your patience. I appreciate it.
Understood. My name is Laura, Laura, and my last name is spelled Kruskall. So, and again, I fully support AB 73.
Thank you. We appreciate your testimony. All right, Cassie, do we have any line?
Chair, there are no more callers in support at this time.
And Madam Vice Chair, did you have a question for one of our testifiers?
Yes, Madam Chair. If Mr. Martin is still available, or the previous testifier, I had a question about the students, if anyone's available.
Mr. Martin, are you still on the line with us?
Yes, ma'am, I'm still here.
That's wonderful, Mr.
Hello?
Martin. Thank you. This is Assemblywoman Carlton. I guess my question is, as far as the students are concerned, we have folks in the queue right now studying for this. And if they were not to graduate before 2024, not be able to become registered before 2024, this will apply to them after January 1st of that year. Are they aware of this, and do they realize that they're going to have to spend another couple of years to get that master's degree level?
Right. So let me provide the best answer I can, and then I may have to also defer to Dr. Kruskall, who deals with students more directly. I can consider myself to fall into this category. I was aware when I graduated that the master's degree was pending, but the Academy has grandfathered in anyone who starts in a nutrition science didactic program prior to the year 2024 would be grandfathered in under the old, let's call it the old requirements. So the Academy also has different pathways. So even though the master's degree will be required after 2024, there are still some other pathways available for becoming a registered dietitian. So I will just add that this isn't a change that is just black and white where they're flipping a switch. This is a gradual transition for the whole profession.
Okay, thank you. I appreciate that. And I always just, when we raise standards on something, we always want to make sure we're not pulling the ladder up behind us, and we're making sure that it's still accessible to those that we're trying to get there, and we're not moving the goalpost on them, so that they
sure, absolutely, and
the end of their education.
And I guess I can add. I guess I'll add that the Academy is aware of that, and they're offering scholarships and various provisions to try and promote diversity within our profession as well, to make the master's level degree accessible to as many people as possible.
Well, we're all very aware of what student debt is. And the last thing I want to see is someone end up with more debt just because they're trying to get, like I said, to that goalpost. So thank you very much for answering my questions.
Great question, Vice Chair. Thank you for that question. Okay, I don't have anyone signed up in opposition to testify on video for AB 73 broadcasting. Can we check the phone line?
To testify in opposition of AB 73, please press star 9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Thank you. We will now take testimony for neutral. Seeing that no one has signed up on video, can we check the phone line to see if anyone signed up to testify in the neutral position?
To testify in neutral on Bill AB 73, please press star 9 now to take your place in the queue. Chair, there are no callers in neutral at this time.
Thank you. And thank you, Ms. Metherell, for presenting Assembly Bill 73. I would like to ask if you would please submit your remarks. I noticed you were reading your script for the presentation. If you could please submit those to our committee manager so she can upload them as an exhibit and it would help her with her minutes. And Ms. Metherell, would you like to give any final remarks?
No, thank you for the opportunity. Also, I'm not sure how it would work, but I would be more than willing to put a grace period into the statutes if that's what the committee desires and how that would look.
Thank you. We appreciate that. We will work with you and our legal on that. Thank you. I will now close the hearing on Assembly Bill 73. The next item on our agenda are two bills from the Division of Insurance. We are going to take these out of order as well. We are going to start with Assembly Bill 18. I will now open the hearing on Assembly Bill 18, and I believe I have Commissioner Richardson here to present the bill. Commissioner, are you with us?
I certainly am.
Welcome to the committee. You can start when you're ready. And is there anyone presenting with you, Commissioner?
Not today, no.
Okay, perfect. Please begin when you're ready.
Certainly. So good afternoon, Chair Howdy and Vice Chair Carlton and members of the committee. My name is Barbara Richardson. I'm the Insurance Commissioner for the state of Nevada, and I'm here to present Assembly Bill 18. So this bill focuses on two areas. The first is to provide Nevada's automobile insurance consumers additional choices regarding their limits of uninsured and underinsured motorist coverage. The second is to help ensure that Nevada's renewal with altered terms, statutory language, cannot limit potential policy improvements for consumers. I will provide you with a brief overview of the changes being proposed in the bill, and then I'll be happy to answer any questions that you have. So sections 1 and 3 of this proposed bill provide additional options to Nevada insurance consumers regarding uninsured and underinsured motorist coverage limits in a policy of automobile insurance. So under current Nevada law, insurers are only allowed to offer consumers uninsured and underinsured limits in amounts not less than the state's minimum limits for liability insurance for bodily injury, and not more than the amount of coverage for bodily injury liability purchased by the consumer. So Nevada's current minimum limits for bodily injury liability coverage is $25,000 per person or $50,000 per occurrence. So language is in sections 1 and 3 provides insurers the option to offer limits of UIM that differ from bodily injury liability limits in a policy. For policies of insurers that choose to make this option available, this change provides Nevada consumers the ability to tailor their coverages to their actual needs for protection. For example, if you're at fault in a car accident and injure somebody, bodily injury liability coverage pays for the other driver and their passengers' medical expenses, their lost wages, legal fees, potential funeral costs, and pain and suffering that the result of those injuries. In evaluating personal exposures and adequate limits of bodily injury liability coverage, consumers may consider the amount of their assets, the net worth that would be exposed, if they were legally liable for the injuries caused by that accident. Underinsured and uninsured motorist coverage pays for the medical bills, lost wages, if you can't work because of the car accident. So pain and suffering, compensation, and potential funeral expenses when you're injured by a vehicle caused by a driver who either didn't carry liability car insurance or doesn't have enough liability insurance to cover the value of your injuries. So when insureds consider the amounts of uninsured motorist or underinsured motorist coverage, they should consider what might be given to the amount of, or should consider what amount of their available liquid assets they might be putting out at risk. For example, do they carry robust medical insurance that may cover their medical bills? Do they have disability insurance that would replace their income in the event of an accident? And there also could be the possibility the accident could make them partially or permanently disabled. They want to make sure that all of those options are covered. The proposed changes in sections 1 and 3 are designed to provide the consumer with the choice to make coverage selections that are right for their individual circumstances. So section 2 is a different animal altogether. It actually changes the language related to an insurer, and that provides or requires that they give at least 30 days notice to an insured prior to renewing a policy, which is technically on different terms or including different rates. So now what we want to do is include a list of exceptions to this notice requirement where the changes are more clearly consumer friendly. The proposed changes also replace different terms and rates with change in policy or coverage to be less ambiguous. Some of the changes where 30 days notice for a change in policy or coverage would not apply consist of, for example, 1, a decrease in the amount of total premium charge, or a change in the effective date or expiration dates of the policy if the duration of the renewed policy remains the same. And 3, an example could be changes in one or more conditions of the policy that are intended to provide coverage, which are more favorable to the insured. Examples of these type of changes would be when an automobile insurer chooses to include towing and road service coverage, or when a house insurer includes identity theft coverage at renewal for no extra cost or premium to be insured. Under the current statutory language, insurers could be prohibited from making these types of policy improvements or providing a rate decrease if they did not provide consumers 30-day notice prior to their policy renewals. The idea is to actually be able to provide that information but not miss out on an opportunity if the insurance company misses the exact 30-day mark. So there is one issue that I did want to bring forward. So there's an item that I'd like to discuss regarding AB 18. So the Division of Insurance was contacted by the Nevada Justice Association on this particular bill, and they had concerns regarding section 1(2)(b) of the bill, which basically says they may offer uninsured and underinsured vehicle coverage in an amount that is greater or less than the limits of coverage for bodily injury. So after long discussions with them, and in order to avoid confusion or concern, the division is proposing deleting section 1(2)(b), and we've been in communication with the Nevada Justice Association regarding this proposal. So this concludes my introduction of AB 18, and I'm available for questions if you have any.
Okay, members, any questions? I will go to the members first.
Yes, Madam Chair. A clarifying question?
Yes, Vice Chair Carlton, please.
And thank you. So we went through an explanation of a section that I believe is going to be deleted. So I just want to make sure that out of all this, we know what's being proposed to be deleted.
For the record, this is Barbara Richardson. It's section 1(2)(b), and the language is may offer uninsured and underinsured vehicle coverage in an amount that is greater or less than the limits of coverage for bodily injury sold to an insured under the policy of insurance covering the use of a passenger car.
Okay, so just that on
just that section.
Page 3, line 3 through 6.
Exactly.
Will be deleted. And so that you people can't undersell and still not have enough coverage. Is that correct?
For the record, this is Barbara Richardson. That's exactly what the Nevada Justice Association was concerned about.
Okay. Alrighty. And the must on the first page is still staying.
Yes, ma'am. For the record, this is Barbara Richardson.
That's what okay. Just wanted to make sure. When I heard 1 and 2, I just wanted to make sure I had it correct. Thank you very much, Madam Chair.
You're welcome, Madam Vice Chair. Committee members, any other questions?
Chair, that was.
Oh, Assembly Member Tolles?
Yes, thank you. And Once again, Vice Chair beats me to it. That was my same section of question as well. But in that last clarification, I just wanted to add to that, it's greater or less than. So both of those parameters, we're just removing that entire section completely because of the concerns around it.
So for the record, this is Barbara Richardson. Yes, it turns out on the forms that you use to actually make a change in those kind of coverages, you are required to actually sign some kind of stipulation with the insurance carrier to make sure that you understand what the limits of coverage are as part of that. So this tended to just confuse the situation. This section did.
Yes, thank you. That was the one question that I had looking at it, reviewing it ahead of time as well. Thank you.
Assembly members, any other questions? Okay, and then Ms. Richardson, I just have one question on that section that's being deleted as well. So then the only option would be if they do decide to do uninsured, underinsured motorists, they have to buy it in the amount equivalent to the insurance amount they have for bodily injury. There's no other option.
So this is Barbara Richardson. For the record, they can actually have more than that on the form itself, but you have to sign something that actually acknowledges that. So this particular section that we're deleting wouldn't have required any kind of agreed or tacit agreement from the consumer itself. So that's why we were removing it.
Okay, perfect. Thank you. And it looks like I don't have any other questions from the committee members. Oh, Assembly Member Tolles? That just, okay. I think that just came in late. Okay. Thank you so much, Commissioner. We are going to go ahead and move into the testimonies, a part of our bill hearing. Looks like I don't have anyone signed up to testify in support on video. So broadcasting, can we check the phone line?
To testify in support of AB 1818, please press *9 now to take your place in the queue. Caller with the last 3 digits of 555, please slowly state and spell your name for the record. You will have 2 minutes and we begin now.
Madam Chair and members of the committee, Graham Galloway on behalf of the Nevada Justice Association, GRAHAM, GALLOWAY. Initially, I signed in this morning or registered this morning for this hearing in opposition, but after discussion with the Division of Insurance and Commissioner Richardson's staff, they have graciously agreed to an amendment that was discussed, which transforms us into a full-fledged, for the record, supporter of the bill. In fact, Section 2 that the Commissioner discussed is very good consumer legislation. So again, once again, for the record, the Nevada Justice Association is in favor and support of this bill. And we extend our gratitude to the Commissioner and her staff for making the amendment. Thank you.
Thank you, Mr. Graham. Mr. Galloway, I appreciate your testimony. Broadcasting, is there anyone else signed in?
Chair, there are no more callers in support at this time.
Okay, thank you. We will now move to testimony in opposition. I don't see anyone signed up to give opposition on video. Do we have anyone on the line?
To testify in opposition of AB 18, please press *9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Madam Chair, you're on mute. That's the new Vice Chair's job now, I think, in this session.
Yes, thank you. You're on top of it. Thank you. We will now move to testimony in neutral. I don't see anyone signed up to give neutral on video. Can we check the phone line broadcast?
To testify in neutral on Bill AB 18, please press *9 now to take your place in the queue. Chair, there are no callers in neutral at this time.
Thank you so much, Broadcasting. Thank you, Commissioner Richardson. Are there any closing remarks you would like to make on Assembly Bill 18?
So for the record, this is Barbara Richardson. No, I don't have any closing remarks except thank you and the Justice Association for working so diligently with us. We appreciate it.
Thank you. I will now close the hearing on Assembly Bill 18 and open the hearing on our last bill for the afternoon, Assembly Bill 4. We have Commissioner Richardson here with us to present Assembly Bill 4. Commissioner, when you're ready. Oh, and Commissioner, I do want to make one request with Assembly Bill 4. I know you did this with Assembly Bill 18, but just if we could take Assembly Bill 4 section by section, just so that in case members have any questions, we can go ahead and jump in. I know it was a bigger bill.
No problem. Good afternoon, Chair Howdy and Vice Chair Carlton and members of the committee. So for the record, my name is Barb Richardson. I'm the Insurance Commissioner for the state, and I'm here to present Assembly Bill 4. This bill addresses changes to the Nevada Insurance Guarantee Association, which is contained in Nevada Revised Statutes, Chapter 687A. So I'm also joined here today by Bob Laudermill, who is the Executive Director of the Nevada Insurance Guarantee Association. And imagine, if you will, you're sitting in the Assembly chambers right now. Bob would be sitting next to me. So Bob is here to provide assistance in answering the committee members' technical questions. And we've also provided an explainer table to the committee secretary, which summarizes both the language and the reasons for the requested changes for each section of the bill. So with this being my first real opportunity to be in front of the Assembly Commerce this session, I'd like to take a few seconds to provide you with a brief overview of how this proposed bill came into being. So the Nevada Insurance Division's primary focus is the regulation of the insurance industry in Nevada, which produces approximately $19 billion of annual premiums written on Nevada-based risks. Nevada's insurance premium tax provides the state's fourth largest source of general fund revenue, generating over $440 million in taxes collected during the past fiscal year. Insurance is currently the largest financial sector in the United States and is the only financial sector that is primarily regulated by the states rather than the federal government. Most insurance carriers doing business in Nevada also transact insurance in multiple states or are considered national companies. So Nevada is a fully accredited member of the National Association of Insurance Commissioners, which is governed by the insurance commissioners from the 50 states, the District of Columbia, and the 5 U.S. territories. Through the NAIC, the commissioners work together to create a regulatory framework that provides increased uniformity for insurers, information sharing, and support to help create more efficient markets and better consumer advocacy. One of the important activities of the NAIC is the drafting and adoption of model laws and regulations, which are created by and voted on by the insurance commissioners through a transparent, collaborative process. And this also includes members of the industry and consumer advocates throughout the entire process. These particular model laws can take years to draft, and making sure that they're open and transparent during the entire process period. These approved models are drafted to provide each state with a base of consistent language to use when proposing enactment through their state legislators. Model legislation helps create efficiencies for multi-state carriers through an improved uniformity of regulation, which in turn helps reduce rates for consumers. Title 57 of the Nevada Revised Statutes and accompanying regulations contain language provided by both the NAIC model language development and model law language developed by the National Council of Insurance Legislators, or NCOIL. The reason I bring this up are that the revisions of this bill, which are intended to update NRS 687A, are based upon model language created by the National Conference of Insurance Legislators, or NCOIL, the National Conference of Insurance Guarantee Funds, and the NAIC. So the Nevada Insurance Guarantee Association, or Guarantee Association, is a nonprofit association created by the Nevada Legislature to pay certain claims of Nevada insurance consumers in the event of a property casualty insurer insolvency. The maximum payout under the Guarantee Association is $300,000 per claimant. All insurance companies that are licensed to sell property and casualty insurance in Nevada are required to be members of this association and all contribute to this fund. Insurance carriers are allowed to offset their insolvency assessments to the Guarantee Association with credits on their premium tax returns at 20% each year for 5 successive years. So insurance solvencies can ultimately create reduced general fund tax collections. So I'm going to go through a brief overview of the changes being proposed in AB4, and then we're going to have Bob available should you have any specific questions about how it might be used or embraced by the Guarantee Association themselves. So Section 1 through 18 removes references to NRS 687A110, as these are in relation to the provisions that are being limited in Section 15 of the proposed bill, and I'll get to that soon. Sections 2, 3, and 4 add definitions for the terms person and self-insured. Section 5 limits the claims which may be asserted against a consumer insured by a policy that is issued by an insolvent insurer. Section 6 adds vendors' single interest and collateral protection insurance to the types of insurance that are not covered by the Guarantee Association and describes what is not covered by the association under insurance, warranties, and service contracts. Section 7 makes this section consistent with the definitions added in Sections 3 and 4. Section 8 amends what type of claims are covered by the Guarantee Association, extends the claim filing deadline from 18 months to 25 months, and lowers the net worth threshold for first-party claims, which are claims made by insureds, to $10 million. So Section 9 changes the amount of the Guarantee Association's obligation requirements by reducing the obligation for unearned premiums to $10,000 and clarifies that the association is not bound by settlements or releases that were entered into the 12 months prior to liquidation. It also adds additional powers to the Guarantee Association and amends provisions regarding lawsuits involving the Guarantee Association. We had some requests for clarification on this section by the Nevada Justice Association, and after discussion with their members, we thought it would be helpful to clarify that settlements referred to under Section 1F do not apply to closed settlements where payments was already tendered by the insolvent insurance company. We'll be working with the association to develop language to provide that clarification. Section 10 removes outdated reference language, and some existing language is rephrased to provide clarification of what the Guarantee Association requirements are in providing a plan of operations. Section 11 requires the commissioner to provide the association a copy of any judicial complaint which seeks an order of liquidation against a member insurer. Section 12 extends the subrogation rights of the Guarantee Association for a cause of action which the insolvent insurer would have if such sums had been paid by the insolvent insurer. It also changes the Guarantee Association's rights of recovering to or on behalf of an insured of an insolvent insurer to only those insureds whose aggregate net worth is more than $10 million and to any person who is an affiliate of an insolvent insurer. This section also adds language to confirm that the Guarantee Association is recognized as a claimant in the liquidation estate of the insolvent insurer. Section 13 extends the type of payers that cannot assert an action against an insured and are required to file their barred claims directly with the receiver of the insolvent insurer. Section 14 restates the current requirement that claimants first exhaust all other available coverage, including a right to a defense, before they may assert a claim with a Guarantee Association. Section 15, which we talked about or noted above, eliminates provisions that cover the notification of the commissioner by any member in a hazardous financial condition or to request that the commissioner order an examination of a member insurer believed to be in hazardous financial condition, and allows the board of directors to make recommendations to the commissioner regarding matters generally related to approving or enhancing regulations for solvency. These changes are being requested because the association doesn't currently investigate nor receive financial information on member insurers that they would need to perform these functions. It also allows the division to make decisions, for example, of not performing an examination, which would then cost an insolvent insurer even more money before we take them to the court if we've already done an examination in the past 3 years. Section 16 expands the immunity of the board of directors, the commissioner, or the representatives of the commissioner to include liability for failure to act. Section 17 changes the time frame an action will be stayed to allow the court hearing an action itself against an insolvent insurer or insolvent policy to have more leeway in the time given to the defendant to prepare a proper defense. This section also amends language regarding access to an insolvent insurer's records to ensure that the association has access to the insurance or the insolvent insurer's records to be able to act in their stead. So lastly, I want to talk about an amendment. The division will be proposing one amendment to AB4. We were contacted by the Nevada Justice Association, who had concerns with Section 9F, which allowed the Guarantee Association to review settlements between the insolvent insurer and a claimant entered into within 12 months before the order of liquidation that have already been funded and paid. Our amendment proposed by the Nevada Justice Association will be to add the word unfunded to the first sentence. So it'll read, it is not bound by an unfunded settlement, release, compromise. This amendment will then clarify that the Guarantee Association cannot change or claw back any funds or settlements that have already been paid out by the insurer. This concludes my introduction of AB4, and Bob and I will be happy to answer any questions that the committee members may have.
Thank you so much, Commissioner. I just had to check to make sure I wasn't muted. I am going to go ahead and go to the members first and see if any members have questions. I will start with Assembly Member Kasama.
Thank you, Chair Hardigy. Thank you so much for the presentation. My question would be, let's see if I can find the section, page 8, which would be section 9A2. And you I'm sure you mentioned or touched on this. My question is, it just seems like such a large amount to go from 300,000 to 10,000. Could you just comment on that change?
Sure. Bob Laudermuck, Executive Director, Nevada Insurance Guarantee Association. Thank you for allowing me to participate, and hopefully I can provide assistance and information. That provision works similarly as the statute contains net worth exclusions, which basically preclude coverage from businesses primarily that may not need to fully benefit or receive funds. And this provision, which would reduce the unearned premium from 300,000 to 10,000, is intended to act similarly, just based on the amount of the premium. A business that has a premium recovery in excess of 10,000 would seem to be equipped to handle the insolvency, similarly to the exclusion or the basis for including net worth exclusions. Most of the other guarantee associations, again, we're trying to tailor everything to the model languages. Most of the other guarantee associations have already reduced the amount of that provision from 300 to 10,000.
Great, thank you so much.
Mm-hmm.
Members, any other questions? Assembly Member Tolles?
Thank you, Chair. And just a couple of quick questions. So in Section 6, subsection 5, I just see that we are, listing out what insurance warranties and social service contracts are. And I know you briefly went through this in your overview, but if you could just help me understand a little better how we came to this list. Is that simply that model language?
Bob Laudermilk again. Primarily, that provision is 020 is the applicability section of the Act, and it's basically an attempt, the provision to only cover direct types of insurance. So items that are within the credit insurance statute, which is NRS 690.015, are generally excluded or the Act shouldn't apply to them. And the basis would be there's no transfer of risk or they involve guarantees. And again, it's not a direct form of insurance. And the item that you mentioned basically relates to service contracts, which are mentioned or referenced in NRS 690.C. So it's basically to only apply the Act to direct forms of property and casualty where there's basically a transfer of risk and an attempt to avoid guarantees or warranties, service contracts, life, disability, unemployment type of insurance.
Great, thank you for that. I appreciate it. I have to ask just out of pure curiosity, and I know this is not a change that's being made, it's already in NRS statute, but we offer ocean marine insurance. Is that for cruise ships, or I don't think we have a whole lot of marine activity in the state of Nevada.
but-
So I had to
yeah.
ask.
Yeah, well, that's one that would be excluded as applicable.
Okay, got it.
So the statute wouldn't apply to.
So it would not apply to that.
No, events over water, title insurance, ocean marine would not apply. That's already in the statute, but yes.
Right.
Yes.
Okay, thank you.
Okay, I don't see any other questions. An assembly member asked one of my questions, which is great. But I have a question in that section as well still, because I know we're adding to the list. Has there ever been any claims paid out through the Guarantee Association for any of these types of insurance policies that are now newly being added for any companies that went insolvent?
I do not believe so. So no.
Okay. And then I believe that answered all of my questions too. Let me just, okay, members, any other questions? Okay, I think we're good. We'll go ahead and move into our testimony portion of the bill hearing. I do not have anyone signed in to testify on video in support, so we'll move to the phone line. Broadcasting, if we could please check to see if there's anyone here in support on the telephone line.
To testify in support of Bill AB4, please press *9 now to take your place in the queue. Caller with the last 3 digits 555. Please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Madam Chair, members of the committee, Graham Galloway on behalf of the Nevada Justice Association once again. And once again, I initially registered for the hearing as in opposition, but after further discussions with the Division of Insurance as well as the Guarantee Association, the amendment came to fruition that we asked for, and therefore we are in support of this bill. And again, we extend our gratitude to the Division of Insurance as well as the Guarantee Association. Thank you, Madam Chair.
Thank you for your testimony. Broadcasting, do we have anyone else on the line?
Chair, there are no more callers in support at this time.
Thank you, Broadcasting. And we will move to testimony in opposition. Seeing nobody on video, we can go directly to the phone line.
To testify in opposition of AB4, please press *9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Thank you, Broadcasting. Now we can move to neutral. Seeing nobody on video, we can go directly to the phone line.
To testify in neutral on AB4, please press *9 now to take your place in the queue. Chair, there are no callers in neutral at this time.
Thank you, Broadcasting, and thank you, Commissioner Richardson, for presenting Assembly Bill 4 this afternoon. Any closing remarks?
No, thank you very much for hearing our testimony today. Appreciate it.
Thank you, Commissioner. I will now close the hearing on Assembly Bill 4 and move to our next agenda item, which is public comment. Before we go to this agenda item, I would like to remind those present that the period for public comment is an opportunity to discuss general matters that fall within the purview of this committee. The public has already been given time to support or oppose specific legislation. We open and close hearings on bills so that we establish a record of the public testimony on the bill. We do take 30 minutes of public comment, and public comment may be limited to 2 minutes. Broadcasting, do we have anyone on the line for public comment?
To To take your place in public comment, please press *9 now to join the queue. Chair, the line is open and working. There are no callers at this time.
Thank you, broadcasting. If we could just wait 1 minute to give anyone who's listening over the internet time to log on or call in.
Okay.
Broadcasting, has anyone called in?
The public line is open and working. There are no callers at this time.
Okay, thank you. Okay, members, that concludes our meeting for today. I would like to let you know that our next meeting will be scheduled for Monday at 1:30. Thank you for being here today. Meeting adjourned.